Welcome, everyone. We're going to get started in just a few minutes. If anybody already knows a question they would like to ask, they can send it in a chat to me and Liz. As co-hosts, we should both get that. If not, I'll send it over to Liz, and we will field questions to Ken at the end of his presentation. Ken, is that you? 857?
That is Ken, Yachad.
Great.
Hello, Yachad.
Hi, Ken. Can you hear us?
I can hear you. My computer just went totally black. I don't know what happened. I suspect it's on my end, but I don't really know why it happened.
All right, it's a little bit hard to hear you.
It's hard to hear me now. Okay. Is this better?
Not yet. My computer is not working. It was working, as you now know, and it stopped. Maybe I should call back in. Maybe I'll get a better connection.
Okay, I think also if you're just very, very loud, it's just very soft. So I think if you can be very loud. Do you have a landline, Ken? You're using your cell phone. Can you call from a landline?
I'm using a landline.
Okay. All right. I guess then try calling back in.
Yeah, let me call back in.
Thank you, everybody, for your patience. A few more minutes, and then we'll get started.
Yachad? Yachad?
Yes.
All right, it said you had to unmute me, so maybe you've done that?
Yes, we
Yes.
can hear you. Very good, Ken.
Okay, you can hear me better now?
Much better.
Good, good. I apologize. I don't know what happened. I don't know if it's, I just don't know. We were connected and suddenly my screen just went black. And I can't seem to restart it, which is a shame. But you can see the PowerPoint?
Correct.
Okay. And if, are we ready to start? Did I miss something?
No, we have 3 more minutes.
Okay.
There's about 20 people here now, and I keep getting more and more emails.
Okay, well, that's good.
People wanting to join. So let's give it a few more minutes. And
Sure.
yeah, I'm glad we have your connection set up. And if anybody has a question right now that they want to put in the chat, feel free to do so, and we will field questions at the end. And Ken, if you have a copy of your presentation in front of you, you'll just tell me when to go to the next slide.
Yeah, I may not be very religious with that.
Okay.
I think given the fact that we just have an hour to do this, so anyhow, we'll figure it out.
Okay. I'll try to keep up. So one question off the bat, Ken, while people are getting situated, we have people joining us tonight from all across the country.
Okay.
Before we begin, is this presentation relevant to people outside of Massachusetts?
To a certain extent, yes, but each state has a sort of different nuance, there are different between states. So generally speaking, yes, but the answer is no. I mean, in terms of giving accurate advice, and I wouldn't, attempt to give advice for someone living in Pennsylvania.
Okay. All right. So then everybody joining, feel free to make your own decision. I think Ken will probably still say things that are relevant to you, and but each state is slightly different with their process.
So strange.
So it is 8:15, and I'm an on-time kind of person, so I think we should begin. Welcome, everybody. My name is Yachad. I'm the manager of the social work department in New England, Yachad, and I'm joined tonight by our director, Liz Offen, and our speaker tonight is Ken Shulman, who you cannot see, but we can hear. Ken is a partner in the Day Pitney firm, and he is a close friend of Yachad and helps a lot of our families with their guardianship and estate planning needs. And he's done a few seminars for us in person, and we're very lucky that he agreed to speak to us tonight over Zoom. And since his video is not working, you will hear him, and hopefully everybody can see his presentation that I'm sharing on my screen. If you have a question for Ken, please put it in the chat, and Liz and I will, oh, someone said it's harder to hear Yafa than Ken. Can people not hear me? Okay. You can hear me? Okay. I'm not talking for long. As long as you can hear Ken, that's what matters. If you have a question, please send it to me in the chat. This is being recorded, so we can send you the recording after if somebody needs that. And Ken also made a PowerPoint for this occasion, and I can send that as well if people would like that after the fact. I might just need an email reminder. So I'm just going to put my email in the chat now that you can email me later if you would like either of those items. And we are so happy that all of Yachad is here with us, that this was open to all regions. If everybody could either add to their name or put in the chat to me where they are calling us from, we would love to know where everyone's from. It's too big of a group to go around and do an icebreaker. So feel free to just share either in the chat or add to your name so we can just see where everyone's calling from tonight. And with that, I'm going to turn the floor over to Ken and Liz and I, and also our social work intern Shannon, are all on tonight to assist. So thank you, Ken. Take it away. Ken, are you there? Where'd he go? Ken, are you there?
Yeah, no, the system muted me for some reason, perhaps because I wasn't saying anything, but now I'm here. So,
okay, good.
Hello, everyone. So you can hear me, correct?
Yes.
All right, and I apologize for the technical difficulty, which is very much on my end. My computer screen just went black, and I can't seem to make it resurface at this point. So I will talk to you, and hopefully Yafa and Liz can follow along in the PowerPoint. Though I'm really not going. We only have an hour, and so I'm really not going to stick to that in any great detail. It will be available for you to review. But since we only have an hour, what I thought I would do is speak to you for 15 or 20 minutes, and then take your questions, because I think that's more valuable. Whether we're in person or doing it virtually can be more valuable to you, and I can try to answer your questions without being too specific. I won't be able to give individual legal advice to any of you, which I'm sure you understand. So I thought maybe the way to approach, because some of what I'm going to say is going to have a lot of relevance to many of you, some of it less relevance to others. I think we all have something in common here, is that we all have family members who have some level of disability. But that can vary greatly. We, can go from a child with Down syndrome or severe intellectual disability to someone with psychiatric issues or high functioning autism. And the issues are similar that all of you are going to face, but they're going to be quite different in terms of the planning you're going to do and the issues you have to confront. Not to say one is easier rather than the other, but someone who has a child with Down syndrome is going to have a very difficult and time in terms of, or different kind of journey than someone who has a psychiatric illness, for instance, or someone who has high functioning autism and is able to work but not necessarily support himself independently. So I think the best way to start maybe as a sort of introduction is to speak to you, and I assume most of us are on the call are parents, though there probably are some people who have disabilities themselves, and I want to speak to those issues as well. But I think if I sort of think of you as clients and who are coming to me and saying, we understand, Ken, that you are an estate planning attorney that helps families with children with disabilities do their estate planning, let's start with that. And so the first issue that very often comes to me is when parents come in to see me, they are certainly concerned about financial issues and public benefits programs, and they've heard about these things, some more or less depending how old their child is and where they are in the system. But one of the things that keeps them up at night, even more than sort of the financial issues and the estate planning issues, is who's going to sort of advocate for my child when I'm no longer able to be here to do so. I passed away, or I'm disabled myself, or my child is in a different place. And I'm not at all sure whether my child can make independent judgments himself or herself. So that inevitably turns into a discussion about guardianship. So I wanted to spend a couple of minutes just talking about that, and then if you have questions about it, we can speak to those later on. So in all of our states, all 50 states, and I'm in Massachusetts, as Yachad indicated, but in all 50 states, until a person is 18, their parents have the legal right as natural guardians to make decisions for them. But once they turn 18, regardless of their abilities or inabilities, as it were, the child is deemed to be emancipated in the eyes of the law. And an emancipated person can make decisions for himself or herself, which means that the parents don't have the absolute decision-making authority that they had before the child turned 18, regardless of the child's true abilities. And that would normally mean that the child is the person who is the one who can make medical decisions for himself, educational decisions, and residential decisions, and all the kinds of religious decisions, all the kinds of important decisions that we make. So if the parents want to regain that authority to be able to be the legal decision maker for their child, they have to go through the guardianship process. And guardianship basically is, once you go through it and obtain it, it's a judicial declaration that your child is not competent. So it's a pretty weighty thing to do. And when I started this work, years and years ago, the courts were pretty cavalier about it, as was the law, generally speaking. And if a parent brought a petition, and typically in the probate court or the surrogate's court, seeking to be appointed as their guardian of their child, and presented some modicum of medical evidence about why the person needed a guardian, the courts were pretty cavalier about granting the guardianship. But that has changed fairly dramatically over the last 20 to 15 years or so. And now in Massachusetts, for instance, there's a bias against guardianship, so that the law itself presumes that a person is going to be competent, and that a guardianship should only be granted if, in fact, the person is truly not competent to make decisions. And part of the bias in the law is if a guardian is needed at all, it should be a limited guardian unless the circumstances dictate otherwise. Massachusetts and all the jurisdictions, in order to proceed with a guardianship, are going to require that some kind of medical proof be presented to the court. In Massachusetts, for intellectual disability, it's a clinical team report consisting of a physician, licensed psychologist, and a social worker. Other jurisdictions might have a neuropsychologist and or a physician. Some jurisdictions just a psychologist, and that will be dependent on the jurisdiction. Some jurisdictions will appoint a lawyer automatically for the person over whom guardianship is sought to present their side of the story to the court, whether a guardian is needed or not. Moreover, the law has changed over years, and particularly in Massachusetts, which I can speak to with more authority. In the old days, if you were a guardian, you had all kinds of authority, deciding where a person lived, medical decisions, educational decisions. And if you were under guardianship, you lost the right to vote, perhaps lost the right to enter into contracts or marry. Now there are certain kinds of decisions, particularly decisions about treating the person under guardianship with antipsychotic medications, or admitting them to a psychiatric facility, or consenting to some kind of experimental or controversial medical treatment like ECT, for instance, or sterilization, where the guardian has to have specific permission from the court to be able to do that. And at that point, the court certainly is going to appoint an attorney for the person under guardianship to contest that. And typically the courts appoint lawyers on a list to represent your child, if that's the situation where you're petitioning for guardianship. So guardianship is, I think, an issue that, that parents face all the time. Their child turns 18, even if they have a significant disability, parents no longer have the absolute right to make decisions for their child, and so the issue of guardianship has to be contended with. And also, if the situation is such that your child needs a guardian, as part of the ongoing plan that we're going to be talking about tonight, you have to think about, well, who can be the guardian if I'm no longer able to do it? And so we can talk about that a little bit as well. Massachusetts has bifurcated the role of guardian and conservator. Some states have, some states haven't. In some states, a guardian is called a conservator. So the nomenclature is a little bit different from state to state. But in Massachusetts, a guardian has the authority over personal decisions like medical care, educational things, residential, religious. A conservator, on the other hand, would have authority over the person's money or their estate. And very often, if we're doing estate planning for a child with a significant disability, we're not going to need a conservator because the money that the person is going to have is going to be in a trust and is going to be outside of their control of the conservator. But should a conservator be necessary, and a guardian for that matter, there's going to be a requirement that the guardian or conservator report to the court each year. On the guardianship side, it would be more about how the person is doing, what kind of treatment they're in, what kind of therapy they might be, how they're progressing, what their strengths are, what their weaknesses, in some kind of annual report. If they're being treated with antipsychotic medications, then that has to be renewed each year in most jurisdictions, that authority. For a conservatorship over the financial matters, if one is appointed, then there's an annual report of how the money came into the person's name or the conservator's name for the benefit of the adult child who's under conservatorship, how it's spent, sort of an ABC accounting. This much money came in, this is how we spent it, this is what's left. And that has to be done on an annual basis, and that can be, quite frankly, quite time-consuming and somewhat expensive. And so we try to, in my practice at least, avoid conservatorship-type arrangements. I know was a anticipatory question about whether Social Security accounts, someone asked, have to be included on a conservatorship account, and they don't really have to be, at least in Massachusetts. So we very often have people here who are on SSI or Ssdi, but don't have a conservator, even though they're not really competent to manage those funds. They instead have a representative payee through the Social Security Administration. So anyhow, I think initially, just again, I want to only speak about 15 or 20 minutes, is that the initial issue that I think parents have to grasp and come to terms with is, once my child turns 18, is a guardianship necessary? Knowing that it's much more difficult to obtain these days, knowing that it's a judicial declaration that your child is not competent, and depending on, again, where you are on the scale of disability, that can be a really demeaning kind of thing for someone who has a minor disability, for instance, and has some difficulty with executive functioning or coping with certain kinds of things, but having him or her declared judicially incompetent by a court can be, a major blow to self-esteem. That's part of the whole dilemma in dealing with this whole disability world where we have to come into contact with. So, in my PowerPoint, I said, if you've met one family who has a child with a disability, you met one child with a family with disability. I think that aphorism is true. And as I said earlier, some of you are going to certainly need to be appointed as guardians of your children, or to think that through very carefully. Others may not. And for those of you who don't and have, again, adult children, if they don't need a guardian, don't require a guardian, and this is in the PowerPoint as well, you may want to think about encouraging your adult children with some kind of disability to execute powers of attorney or HIPAA releases or healthcare proxies, medical directives to allow you to have access to their financial and medical records to the extent that that would be advisable. So part of this whole estate planning process, I think, is the notion that it's really, you don't do any of this in isolation. You're going to be talking about the issues of guardianship, whether they're necessary, what other assistance might be available to assist your children that are less dramatic and invasive than guardianship, and whether powers of attorney, healthcare proxy, and those kinds of things could be indicated. The other sort of part of the presentation has a lot to do with public benefits, which are sort of the linchpin upon which estate planners who help families who have disabled children have to sort of understand, and you have to understand in order to be effective advocates and for estate planners to be effective estate planners. Unfortunately, a lot of the programs for people with disabilities in the U.S. were grafted on, and I'm talking about public benefits programs, were grafted onto poverty level programs. So for several of them, in order to be eligible, not only do you have to be disabled, but you have to be impoverished. And so it's important to understand what these programs are, and also to understand very clearly that even the officials from Social Security, Medicaid, housing authorities, departments of developmental services, departments of mental health, are very often confused or misinformed about the eligibility criteria for these programs, and quite frankly, sometimes I get confused about them too. They're not very rational. They sometimes seem to be counterintuitive, or in fact even counterproductive for if the goal is to have people be contributing members of society and accomplishing as much as their abilities will allow them to do. So my caution as I talk about this is, if you hear from a DDS, Department of Developmental Service worker, or someone in mental health, or even Social Security about a program and why your child is or is not eligible for it and what they might have to do, they are not necessarily correct. And sort of the notion of trust but verify is really important. I mean, sometimes it's a misinformation on the part of the government worker, and sometimes, quite frankly, is that they would like to interpret the laws the way they think they should be rather than the way they are. But let's start, I mean, with the notion that your child has a disability and may be eligible for some public benefits to help them along the way, and frankly help you out financially with and on a medical insurance basis with your children. So there are two basic stipend programs that are available for people with disabilities, and two medical insurance programs that are related to each of those separate programs. So the first program and typical program is called the SSI program, Supplemental Security Income. And Yachad and Liz, there's a whole section on these government benefit programs in the outline in the PowerPoint. So the SSI program is a means-tested program, meaning that in order to be eligible for the program, besides meeting the Social Security definition of disability, which I'll discuss in a minute, you have to be impoverished. You have to have less than $2,000 in countable assets. And countable, I want to emphasize that. Countable assets are things like cash, stocks and bonds, rental properties. Countable assets are not things like computers and personal property. Theoretically, one could even own a house and still be eligible for SSI, because a home or a condo is not a countable asset. But the reality is that if you're on SSI, you can't afford to live in the house you would own. So most people on SSI do not own their own homes. So SSI is means tested. You can only have $2,000 in countable assets. And until a child is 18, his parents and assets and income are deemed to be available to the child as if they're owned by the child. So most children, even if they have a severe level of disability, and if they live in an intact family who has working parents and a house and some assets, they're not going to be eligible for SSI until they're 18. But once they're 18, if they have less than $2,000 in countable assets and meet the Social Security level definition of disability, which is inability to engage in substantial gainful activity or employment due to an impairment or a series of impairments that is essentially chronic, and if they meet that definition of disability and have less than $2,000 in countable assets and less than a certain maximum amount of income, and I'll talk about that in a minute, they can be eligible for SSI and they can receive a stipend. And the stipend is going to depend on a couple of things. It's going to depend on their living situation, and it's also going to depend in what state they live in, and it also would depend if they're blind, because you get a little bit more if you're blind. But if you live at home with mom and dad, you get the least. In Massachusetts, that's currently about $600 a month. If you live in a group home or some kind of apartment that's a group living situation, you get something more. And if you live independently, you get the most. In Massachusetts, that's about $900 a month. In Massachusetts, part of that $900 a month comes from the federal government, and part of it comes from the state. Not all states give a state supplement. So the maximum amount in some states that one can receive is $772 a month. In some other high cost states like California and New York, you're receiving more than the $900 a month that you would be receiving in Massachusetts. It might be as much as $1,000 or $1,100 a month. But so if you're on SSI, you'll receive that stipend based on your living situation. And in most states, you also receive automatic eligibility for Medicaid. Medicaid, not Medicare, but Medicaid. We call it Mass Health in Massachusetts. It's called different things in different states. Connecticut calls it Husky Care. California calls it Medi-Cal. It varies in terms of the state of what it's called. But Medicaid or Mass Health is a health insurance program which is much broader than just a health insurance program. It not only pays for sort of basic health care and hospitalizations and doctor's visits if in appropriate clinics and that sort of thing, but it pays for transportation and group homes and vocational rehabilitation and extended physical rehabilitation and something called personal care attendance if the person receiving Mass Health needs some assistance at home with daily living skills. So it's an extremely important benefit for people with disabilities living in the community, and it's something that we try to preserve. In the old days, you had to be pretty much on SSI to receive Medicaid. Now, in most states, recognizing a couple of things, that sometimes people with disabilities are not eligible for SSI, but still have great medical needs. In most states, you can get Medicaid independent of SSI if you are medically needy. But that depends on your state, and so that's the kind of thing you would have to consult with a local lawyer. But preserving Medicaid is extremely important for people living in the community who have disabilities, significant disabilities. Now, so SSI is means tested, which also means it's very rigorously supervised and judged by the Social Security Administration, and has very sort of aggressive and unfriendly rules, so that if a person on SSI receives money from somebody else on a monthly basis, they don't count the first $20, and it could be somebody else or it could be a trust. They don't count the first $20 a month that the SSI recipient receives, but for every $20 after the $20, they just reduce the SSI payment dollar for dollar automatically to zero. So in my example, if someone were living in the community getting $900 a month and his parents gave him $520 a month, it would reduce his SSI payment by $500, and now we would get $400 from SSI and $500 from the parents. So direct gifts or direct gifts from trust are not, not a wise thing if a person is on SSI. If another person pays for food or shelter, or a trust pays for food or shelter, it will reduce the SSI payment not dollar for dollar, but by a certain amount, called 1/3 of the federal benefit rate, so 1/3 of that $772 I mentioned. And sometimes we do that. Sometimes we have trust. Look, if you're living in Boston and you get $900 a month, you can't really afford to live in a very, safe apartment in a good neighborhood if you're going to be living by yourself. So sometimes we have a trust actually pay the rent in a very nice apartment, and perhaps depending on the size of the trust, pay $2,500 a month for the apartment, which is near work perhaps, near medical care, near a community, day hospital, wherever it might be, that reduces the SSI payment by $200 and some odd based on that 1/3 of the federal benefit rate, but it gets the beneficiary to be able to live in a nice, safe environment. So we're going to talk about trust in a minute too, and that's just an intimation that the selection of a trustee for a special needs trustee is perhaps the most important decision you're going to make in this process. I mean, special needs trusts, when I started this work, were unique and sort of unfamiliar to Social Security and to the Medicaid people, but now they're part of the lexicon. And they are, if they're properly drafted and properly administered, they're going to work. But the key is in the administration. Let me briefly talk about the other sort of major benefit program for people who have disabilities. And that, the stipend program is something called Ssdi, Social Security Disability Income.
And we lost you. There you go.
Oh, not sure.
We want to hear about SSDI.
All right, Ken, are you back?
Yafa,
Okay.
are you there? You're back? Okay, sorry about that. Good. I panicked. So the other is Social Security Disability, Ssdi. And the way one becomes eligible for Ssdi is any of us who are working and paying into the Social Security system and pay our FICA taxes, if we become disabled and are unable to engage in substantial gainful employment, the same definition that I gave with SSDI, we can be eligible for Ssdi, which is an insurance program. It's not means tested. Bill Gates could get Ssdi. It's only based on your earned income. So if you're disabled and no longer be able to earn income, and you meet the Social Security definition of disability, you can get Ssdi. And the amount you receive is based on how much you paid into the system. And once you're on Ssdi, after 2 years, you have automatic eligibility for Medicare. Not Medicaid, but Medicare, which is the program that we associate with older people, like myself. And it's a good health insurance program. It's a good medical insurance program. It's good hospitalization, but it doesn't offer a whole lot for people with disabilities who live in the community. So most people who are on Medicare either have a Medicare supplement or, and I'm going to talk about this in a minute, may still be eligible for Medicaid, which is more important. So people who have disabilities sometimes work, right? And hopefully they will work and launch. And they work, and then either there's a decompensation, or they become physically disabled, or their mental situation worsens, but they have paid into the Social Security system enough to be eligible on Ssdi on their own earnings record, and they can be eligible then for Ssdi rather than SSI. You get more money, typically, and it's not means tested. The other way people get Ssdi, and it's particularly people who have severe disabilities and who are unable to engage in substantial gainful employment themselves, is if they have a parent who is either deceased or starts drawing Social Security themselves. In other words, the parent has paid into the Social Security system. Then the disabled child, who is now known as a disabled adult child, assuming they have not become substantially gainfully employed themselves, can get Ssdi based on their parents' earnings record. So in a case with someone with a severe disability, the typical progression would be, let's say it's a Down syndrome child who can't work, at least can't make substantial gainful employment. They start out on SSI when they're 18. Now they're 44, and their parent has retired and starts drawing Social Security. They will be bumped up from SSI to Ssdi on their parents' earnings record, and they will receive, if it's a a married couple, they will receive, if both of them are drawing, they will receive 1/2 of the highest benefit from the mother or father. And when the mother and father are both deceased, they will receive 3/4 of that benefit. So typically it's much higher than the SSI benefit, which is capped at $900 currently, at least as I said. And it's not means tested, which means that the kinds of things I talked about before, like giving money directly to the beneficiary or paying for food or shelter, don't have any impact on the SSDI payment. The SSDI payment will remain intact even though the person is getting supplements from the trust or from a third party or gifts or whatever it might be. Now, the substantial gainful employment thing I mentioned about the definition of disability, inability to engage in substantial gainful activity due to an impairment or a series of impairments that's chronic, also has a financial component to it, so that if you make over $1,260 per month in 2020, without Social Security will determine you to be no longer disabled. And if you're on SSI and you're making that, you'll be shut off, because SSI has a rule that if you're working on SSI, they don't count the first $65 you earn, but for every dollar after that, they reduce your SSI payment by 50 cents. You're still better off working on SSI if you can. You'll get more ultimately, but it's actually fairly punitive about working. SSDI, for whatever reason, has a much more benign treatment, so that if you are on SSDI and you're working but you make less than $1,260 per month, you're able to keep both what you make from your earnings and the Social Security disability insurance payment. So if you have someone, for instance, I have a lot of clients who have, you know, sort of lower level jobs, perhaps working as a stock person at Whole Foods or pushing carts or working as in the copy room, they're on SSDI and making, you know, $1,000 a month. They're able to keep that $1,000 a month plus their SSDI payment. So that puts more money in the household as well. The punchline of all this is that you as advocates and parents and people sitting on my side of the desk really have to understand these programs and understand the nuances and the eligibility criteria. I mean, I have people coming to me all the time who say, who are older and have children in their 40s or 50s and say, my child can only have, you know, is severely disabled and can only have $2,000 in countable assets. And I think to myself, I wonder if that's really true. And then I say to the clients, well, how much money are they receiving each month? And they say, oh, it's $1,500 from SSI. Well, I know it's not $1,500 from SSI because the most you can get is $900 if you're living independently. And people all the time I hear all the time, my child can only have $2,000 in countable assets. Now, it may be important for other reasons that their countable assets be kept at that level or something low because they have judgment issues or people might take advantage of them or those kinds of things. But in terms of eligibility for public benefits, that may or may not be the case. Subsidized housing doesn't have an asset limit, for instance. So people all the time say, I'm on subsidized housing, Section 8, I can only have $2,000 in countable assets. That's what they told me at the Housing Authority. Well, that's incorrect. So my point is sort of a trust and verify. Now, what I'm going to say before I open to questions now is that typically, you know, people in the Yachad audience are going to have an estate plan that includes a trust for the benefit of their child with a disability. We call them special needs trust. It doesn't necessarily have to be a special needs trust, but it has to be a trust that's purely discretionary. We tend to dress them up and call them special needs trust because the Social Security people like to see certain bells and whistles in them, and so we put those in. But that kind of trust is going to be what we call solely discretionary. So all decisions about how the money is going to be spent for your child with a disability are solely in the discretion of the trustee. In a more typical trust, the trustee is required to use the funds for the child's health, education, maintenance, and support. If you put that kind of standard in the clause, lawyers, Social Security, the IRS calls that an ascertainable standard. And if that kind of standard were in the trust, then the Social Security Administration or Medicaid could say to the trustee, you have a duty to use these funds for their health, education, maintenance, and support. Use them. And when the money's all gone from the trust, come back and see us. With a discretionary trust, there's no duty. It's solely up to the trustee to do it. So that's why your selection of trustee is so important. That's why you sort of have to, with a letter of intent or a memorandum of instructions, inform your trustee about your child from the granular, like diagnosis, siblings, likes, dislikes, medications, allergies, to your more aspirational notion about how you would like to see the money in the trust spent for them. The final thing I'll say before I open it to questions is that you don't do this kind of planning in isolation. The special needs portion of your estate plan has to be integrated into the overall estate plan. Some of you are going to live in states with estate taxes, like Massachusetts. You're going to have to make sure that you integrate and do the tax planning you need to do to maximize the funds that are going to be available for your child. You may have to think on a financial planning basis of trying to leverage assets so more will be available for your child at your deaths, with perhaps using some kind of permanent insurance if you don't have the kinds of funds available to you to meet this need, which you may not normally do in a typical circumstance. You have to let your extended family know that if you have a child who's on a disability or a means-tested program, that they can't leave money directly to them, that you have going to set up a trust for them and they should leave the money to the trust. You have to tell your own parents that they may need to adjust their estate plan because it typically says, I leave it to my child, which would be you. We're talking about the parent generation. But if he or she my son or daughter is not living, then it goes to his or her children, my grandchildren. And if one of them is on means-tested public benefits, the bequest has just made them ineligible. So you have to sort of have communications with the extended family, which are sometimes difficult about these issues. You have to determine, whether siblings are the right people to make decisions for your child with a disability if they're not capable to make them themselves when you're not able to do so. That can be very difficult and create a lot of issues between siblings that sometimes, if a sibling relationship is the only one that's intact with like someone with autism, and the neurotypical brother controls the purse strings, or sister, it can really strain the relationship, and you have to think that through. So these are sort of some of the things that I think about, and I wanted to sort of suggest to you as an estate planner who's been doing this for quite a while, the kinds of issues that come up when I meet with clients. And having talked too much, I'll now open it up to questions that, Liz or Yafa, you can pass along to me.
Great. Thank you, Ken, so much. We have lots of questions, so people should feel free to continue to text me. Let me start off, though, with a point of clarification, Ken. In the beginning, you spoke about countable assets as less than $2,000, but it seems that in some circumstances, you said that's not necessarily the case. Can you just clarify?
Well, because SSI, that's absolutely the case. You can only have $2,000 in countable assets. And if you go over that amount, you won't be eligible for SSI. There is a program called the Enable account, which is, and I don't want to go into too many weeds because I think that will create confusion, which I obviously just did based on the question you raised, Yafa. So SSI, you can only have the $2,000, and that's going to be most of our children turning 18 who have significant disabilities, okay? Ssdi, you can have $14 million. There's no asset test for Ssdi. That's the difference. So the program is SSI, means tested. You cannot have more than $2,000 in countable assets, and you can only have a limited amount of income of any kind, earned or unearned. Ssdi, which is the program where either we have become disabled ourselves and then we paid into the system, Social Security system, or we have a child who's never been substantially gainfully employed himself or herself. We now, as the parent, retire and start drawing Social Security. Then the child is bumped up, if you will, to SSDI on the parent's earnings record, and there is no longer a means testing for that program. Does that make it clear?
Okay.
I don't think it makes it clear, based on your hesitation.
I'm not sure, but let's move on. And I think that you did clarify. Let me ask you, we have an inquiry. How do you make distributions over $20, which is what you mentioned, on a practical level? How do you practically do distributions over $20 without disqualifying from?
It's extremely difficult. I mean, SSI is a punitive system. It's not very user-friendly. So, first of all, the person who is receiving the SSI, whether needs to spend that money himself or herself. You're not saving the SSI money. So, hopefully the SSI will pay for basic room and board, whether it's at home or in a group home or other kind of residential setting, okay? Then there are certain kinds of things and this particularly pertains to distributions from trust or from parents. Giving money directly to the SSI beneficiary is income. You don't count the first $20, as I indicated, but for any dollar over that, technically speaking, it reduces the SSI payment dollar for dollar. Or if you pay for food or shelter, it reduces the SSI payment. In other words, if a parent was to pay the rent where their child lived, that would reduce the SSI payment as well, not for dollar and dollar. However, if you buy a computer for your child with a disability, that's not income. That's not giving money directly to the child or paying for food or shelter. You can buy a computer, you can buy clothes, you can pay for a tutor, you can pay for transportation, you can put gas in the car. You can't give the money to the beneficiary, but if you pay for those other things directly, that's not income to the SSI beneficiary. Got it. The other thing that's available now, which is relatively new, is the ABLE account, which is it's not a substitute for estate planning, but you can put $15,000 per year into an ABLE account. ABLE accounts were grafted onto the 529 college savings accounts for people going to college, for people with disabilities. And if they have a Social Security level of disability, and actually it doesn't even have to be a Social Security level of disability, certification from a physician that they're disabled, you can put $15,000 into the account. Each state typically has one custodian who runs the ABLE accounts. In Massachusetts, it's Fidelity. It may be different in your various states, and in some states you can go to a different state to run the ABLE account. You don't have to use your own state's account. Other places you have to use your own state's account, Florida, for instance. But distributions from the ABLE account, as long as they're used for disability-related expenses is the term, don't count against the SSI $2,000 asset limitation or the income kind of thing. Income, there's no attribution of income. So in a way, when ABLE accounts were started, we thought you could be able to put a lot more money in them and they would be much more effective alternative to special needs trust. That's been a disappointment, but they are something that is a great tool, and in one sense, they're a gift that keeps on gifting. So that's a very good way to sort of circumvent about, giving money to the disabled child, you can put the $15,000 total per year in it. You can't put more than $15,000, and you can only have one ABLE account. Child cannot have more than one, but they can use those funds and they typically get a debit card to do that. It's their money. The downside of the ABLE account is if there is any money left in the account when the person dies, it has to go back to the state. It has to go back to reimburse Medicaid for any expenses that have been paid on the child's behalf. So it's good for short-term kinds of things like gifts from grandparents, or, if you're approaching SSI and you have more than $2,000 in countable assets, you can, let's say you have bar mitzvah gifts or something, and suddenly you didn't realize it, and you have bonds, and suddenly you have $5,000 when you can only have two. You could put that additional $3,000 into an ABLE account and have access to it that way. Now, here's the real answer. People give their children cash all the time and don't report it to Social Security. That, technically I can't advise that, but technically, and you're supposed to report it, but, that the system kind of forces you to do some of these things. The $2,000 limitation for SSI has been the same since 1978. Hasn't moved up. So obviously, it's terrible, but that's where we are. Okay, next question.
So can you answer, when a donor funds a special needs trust, can somebody other than a single donor contribute assets and money? And also, as
yes.
an additional question, can an inheritance go into a trust?
Well, technically that's what's going into the trust, the inheritance, but you want the inheritance to go directly into the trust. In other words, if I'm disabled and on SSI, I don't want to receive the inheritance. The inheritance should go to the Ken Shulman Special Needs Trust. Because if it comes into my hands, then that disqualifies me for SSI. I can't then, I have to transfer it to a different kind of special needs trust, not the one that my parents set up for me, but a different kind of special needs trust that says at my death, if I want to stay on SSI, any money left in the trust has to go to pay back Medicaid for any expense that's occurred on my behalf, that they paid on my behalf. With good planning, that should never happen. We should never have the money going directly to the child with the disability. It should go to the special needs trust. And those don't have to have a payback requirement. The treatment is, much more benign for parents and grandparents who want to create trust for the benefit of their child with a disability. But if the child with the disability either gets an inheritance outright, because of poor planning, or gets a personal injury settlement from a malpractice case or something, or wins the lottery, and they get this money and they want to stay on SSI, and they may or may not, but depending on how much it is. But if they do, they have to then transfer that money, and they have to do it before they're age 65, into a trust that says at my death, at the disabled person's death, Medicaid has to be paid back for everything it's paid, not just since I got the inheritance or not just since I won the lawsuit, but anything that Medicaid has paid for me since I was a day old. So the short answer is other people, not the disabled person himself, certainly can contribute to the established special needs trust. But, the disabled person himself cannot. It has to go to a different kind of special needs trust. And one other thing while we're on that line, that suggests that the inheritance, one of the things I want to caution the audience about is even if you create the special needs trust and you your will say, I leave everything to my spouse, and if she's not living, to my 3 children, and the children for Ken who's disabled goes to the Ken Special Needs Trust, you really need to take an inventory of your assets, because things that have a designated beneficiary are not controlled by your will. They go by the designation of beneficiary. So I can almost assure you even some of you who already have special needs trust, you have 401k plans or IRAs or insurance through work that say, if I die, the funds go to my spouse, and if she's not living or he's not living, it goes to my children equally. And if one of your children, again, is on SSI, you've just made them ineligible for SSI, and you created the need for this payback trust I'm talking about. So once you have the plan in place, you really need to have a clear inventory of all your assets and how they're titled, and make sure you understand that if I have a will that says I want to leave everything I've ever touched, thought about, smelled to Yafa, but my 401k plan says that Liz is the beneficiary, it's going to go to Liz, even though my will said everything I've ever touched and owned and thought about goes to Yafa. So you really have to make sure that your designations of beneficiary are consistent with your overall plan, which is another reason why you just shouldn't do your special needs trust, sort of in isolation. You have to integrate it into everything else. But certainly you could have a parent and a grandparent and an uncle and an aunt all contribute to the same special needs trust.
Great. That's very helpful. Now, let me ask you, in terms of, can a guardianship be reversed? Perhaps it was a poorly informed decision when somebody was younger, and now the family wants to reverse that. Is that possible?
Yeah, it can be. It's going to depend on the jurisdiction. In Massachusetts, what you would have to do is have there would be a petition to terminate the guardianship because the guardianship is no longer necessary because the person doesn't need a guardian based on their current, clinical situation. So you would, and I'm sure it's going to be something similar in each state, you would petition to terminate the guardianship, and the kind of medical proof that was necessary to obtain the guardianship when it was initially taken out would be similar to what you would have to, file in the court to terminate it. You can't it's not self-executing, executing. You have to get the guardianship or conservatorship as a court appointment, so you have to go back to court to have it terminated. But you absolutely can do it.
Now, could you bifurcate the role? So could you maintain guardianship but have someone else manage the estate and the fund distribution?
Sure, you could. Again, in my recommendation would be, maybe the other way makes more sense. Having a conservatorship really requires a lot of detailed accounting to the court about how the money is spent. So I tend not to favor conservatorships for that reason. You have to file a fairly detailed financial plan on an annual basis, and you might even have to have an accountant putting this together depending on how sophisticated the estate was, and a court will appoint a third party from time to time to review the accounts to make sure that they all line up. So, but the answer to your question is yes. In that situation, what you're talking about, depending on, again, all the other factors, it might be more important to have a limited guardian, maybe, than a conservator. I would prefer that if there's a question about competency.
Okay.
Assistance with medical decisions and residential decisions rather than other kinds of things.
No.
Again, it's going to be very much depend on what the assets are,
right,
and what the ability of the person is.
So where you have a situation with multiple assets, and how does one really better determine if they also have a special needs trust account, where to draw funds from? For example, how do you figure out the tax implications?
Well, I think the more, once you're dead, if you're talking about the person with a disability, everything will be coming from the special needs trust. In other words, the estate plan is going to drive, or the insurance policies is going to drive whatever you're going to leave for your child with a disability into the special needs trust. And then the money, the distributions from them are all going to come out of the special needs trust. Now, if you're asking a different question about, are there certain assets that are better than others to fund a special needs trust with, the answer is yes. tangible personal property is not a very, is not a very good thing to put into a special needs trust, for instance. Things that, and this gets a little more sophisticated than maybe you wanted to, but things that are, produce a lot of income, high income kinds of things are not necessarily good to put in a special needs trust, because special trusts have a higher income tax rate than individuals do, in the sense that the income tax rate for trust is sort of collapsed or telescoped, depending on how you want to look at it. But once you get over about $12,500 of undistributed income, it's taxed at the highest rate at the trust level. So what you want to do, and it's really, again, it's the kind of investments, I think, what you're really talking about, what kind of investments does the trustee of a special needs trust want to make? Again, not to get too technical, but the way trust taxation works is that, let's say you got $200,000 in a trust, and it earns $10,000 this year, okay? If you pay that $10,000 out to the beneficiary, or use it for his or her benefit, then that $10,000 of income is going to be taxed for income tax purpose to the individual on SSI. And that's a good thing, because they're in a no tax bracket. You don't want to give them the money directly, but you could use that $10,000 again to pay things that are income for income tax purposes, but not income for SSI purposes. So you can buy a computer, you can send them on a vacation. The trustee can do all of that. That would be income for income tax purposes to the beneficiary, but not income for SSI. And that $10,000 of income in my example would be taxed for income tax purposes to the SSI beneficiary, but no income taxes would have to be paid. If you keep that $10,000 in the trust and don't pay it out, then the trust is going to pay income taxes on it. And as I said, the rate goes up much higher and more quickly than it does for an individual.
Yeah.
So, Yafa, I think you're asking a very good but complicated question. I mean,
these are all complicated. I have a few more for you.
Okay. But I mean, I really think that, the way you ought to analyze this is a family, has assets, has insurance policies, has a 401k plan. Let's say they have 2 or 3 other children. They're going to say, they're going to leave either a third, for instance, and a third for the child with a disability is going to go into the special needs trust. They also may want to have trust for their other children. I'm not saying that the other children shouldn't have trust as well, depending on their ages and their capabilities. But the question then is what goes into the special needs trust. Now, up until January 1st, and this is getting way too complicated again, up until January 1st, we would have said retirement funds are not good to go into special needs trust. But the law changed on January 1st, and it can be that sometimes it's, and I don't want to get in too much in the details, it now can be favorable to have a retirement account go into special needs trust, because special needs trust can spread it out over the life expectancy of the beneficiary. Whereas with the new law, other than a surviving spouse, everybody has to take the IRA or 401k plan they inherit out over a 10-year period. So it's not as tax efficient as it used to be. But anyhow, that's a little weedy, so let's do the next question.
Okay. So along those lines, somebody, can you put stock in either a special needs trust or an ABLE account?
You can put, if you put stock in the ABLE account, they're just going to sell it. So it's not going to stay there. So because again, it's run by a custodian, and they're going to use their own funds to do that. You certainly can put stock in a special needs trust. I will say most special needs trusts, and I would say 98.5% of them, are not funded until the parents die. When they are funded before that, it's typically by a grandparent or an uncle or aunt or someone who wants to make a gift for the person with disabilities, and they know that the gift would make them otherwise ineligible for benefit, make them ineligible for benefits they'd otherwise be eligible for. So they'll make the gift directly to the special needs trust. But most of us don't fund our special needs trust. There's usually not a good reason to do it because of the high income tax rate, as I mentioned and stuff. I mean, there can be exceptions, but most of us don't fund until death.
So if somebody is working, they have disability, they're working, and they're through their employer, they have a 401k or they have a 504b, is that money at risk, either because they're also trying to get government benefits? That's the first part.
Okay, well, probably not, because if they're working and they working enough to pay into a 401k or, you know, a 403b or a 504, whatever it is, they're not going to be eligible for SSI. They're probably going to be eligible for Ssdi, which is not means tested, recall, right? So they're not going to have, that's not going to be an issue. Okay. And Medicaid, if they live in the community, and there are a lot of people who, you know, in this situation who are on Ssdi, as I mentioned, after 2 years are on Medicare, but they're also on Medicaid. If you live in the community in Massachusetts, at least, and I can't answer for every state, you know, on the phone, if you're between 19 and 64, there's no asset test for Medicaid. So that would not make them ineligible. The retirement plans would not make them ineligible for Medicaid. Now, if they were on, and this has happened, if you've just worked a little bit and you do not qualify for Ssdi because you haven't paid enough into the system, but you worked someplace at CBS or something, and then you became disabled and were not able to work anymore, and you had to be on the SSI program, the money in the 403b program does count toward the countable assets. So if they're over $2,000, you would have to take the money out and spend it down until it was only $2,000.
Okay. All right. Let me ask you, Ken, we have about 5 to 6 more questions. We're now at 1 hour. Are you able to stay another 10, 15 minutes?
Well, let's try 10.
Okay, let's go for 10.
And we can go to 15. Whatever.
All right.
No,
Okay.
I'll stay for 15. That's fine.
All right. Thank you so much. Everyone appreciates it. Can you later, let's say you're not on disability, can you apply for benefits? Can your benefits be adjusted later? So let's say you're getting a certain level, but your disability worsens, your cognitive function becomes more difficult, and you're in a different circumstance. Can you apply for your benefits to be adjusted?
Well, it depends on, I mean, if you've been on benefits and then you worsen, no, your benefits, you know, whatever your limit is. I mean, whatever your benefit it is. So in other words, if you're already out on Social Security disability, and you know, because you have a, you know, heart condition, and then you suffer an aneurysm or something later on, your Social Security benefit is not going to go up.
Okay.
Okay.
Right.
Now, if you were a disabled adult child and you had a situation where you're getting half of your parents' income and they die, then your benefit goes up to 3/4 of it. So that's a situation where the benefit goes up. Or if you're on SSI and you're working and it's reduced each month, but you suddenly stop working because you have your disability worsens, your SSI payment will go up to the higher level. But you know, I think that answers that.
Okay. I have 2 guardianship questions. The first is, can you begin applying for guardianship before age 18? Just at least begin the process.
Mm-hmm.
And then the second question is, it seemed a little like you were suggesting that, you know, it's so hard to achieve guardianship, and many people feel that it's better to promote the independence of the individual with disabilities, that there not be a guardian. But at the same time, isn't it in the best interest often of families to resolve difficult bad decisions that their adult child with disabilities made, or sort of some trouble that they may get into by having a member of the family be the guardian?
Okay, so the first question is, this will depend a little bit state specific, and in a sense is idiosyncratic, and even in Massachusetts it may depend on the judge. There are certain judges that will not hear the guardianship petition until the month of the child's 18th birthday, or actually won't even hear it until after the 18th birthday comes and goes. But the process is such that in Massachusetts at least, if you were going to do a clinical, on a basis of intellectual incapacity, you need a clinical team report, this physician, licensed psychologist, and social worker. The report has to be dated with 180 days of the filing for the petition for guardianship. So, and it takes some time to do it. The team doesn't have to meet all together, but physician has to fill out the form, licensed psychologist has to fill out the form, the social worker has to fill out the form. That can take some time to do. So I tend to suggest people start, depending on where we are in the season, whether school's in session or not, I tend to suggest to people they start 3 or 4 months before the child's 18th birthday and get the clinical team report done. And so we can actually file the guardianship maybe 6 weeks or so before the 18th birthday. And then you have to serve it's a lawsuit. Guardianship's a lawsuit. So you have to file the papers in court. Then they issue essentially a summons that your child with a disability will have to be given. And, so that takes some time. And by the time all that runs, he or she's 18, and you can get appointed, fairly contemporaneously with the 18th birthday. So yes, if you start with the day they turn 18, you won't be appointed probably for, at least in Massachusetts, for 3 or 4 months. So you can at least start the process earlier, and I suspect that's the case in other states. Certain judges will not hear it until they turn 18, however.
All right.
So now, in terms of the other question, that's the tension we all face as parents, right? Parenthood is watching your children, regardless of their levels of abilities or disability, try to achieve as much independence as they can. That's without, and so that's the same for children with disabilities. And I think it very much depends. When there's a question, look, some people who clearly have exhibited poor judgment, have been taken advantage of, and there's no question about it. I do think certainly there's a good argument for going ahead and getting the guardianship. But for people who are, may have some executive functioning issues, struggle somewhat in school, have self-esteem issues, but have some abilities themselves. This is maybe a personal thing, but, I would prefer, if I had hesitation about it, personally, I would prefer to try the power of attorney and a healthcare proxy and a HIPAA release before guardianship. Because, and again, it very much depends on, the child and the parent relationship. If the child is really struggling against it, the guardianship, and feels like it's an infringement on their independence and their self-esteem, and particularly if they're taking in Massachusetts antipsychotic meds and they're at all oppositional, they're going to have a lawyer and they're going to have a trial on whether the guardianship is necessary and whether the antipsychotic medications are necessary. And, I think you have to pick your battles.
Okay.
I've just gone through one now where we resisted with a child who, there's some comorbidity with, some autism plus emotional immaturity and outburst, where we tried the power of attorney healthcare HIPAA release, and we've now had to do a guardianship.
Got it. All right,
you know,
Ken, let me squeeze in one more specific question and one more general question. The specific question is, somebody's receiving SSDI and they make much less than $100,000 a year. Are they still eligible for the government subsidy of $1,200?
First of all, if they're making $100,000 a year,
Less. No, they're making much less.
much less. Well, they can only make $1,260 a month to be eligible for SSDI. So we're talking about what's 12 times 12. You know, you can't make that kind of money. You know, you can make about $14,000 a year.
Okay. Thank you. And let me just ask you now that my general question is,
okay,
what's a good place for people to find resources? Especially, is there a site that each state has that sort of explains these very complicated things? Or if people wanted to find an attorney to help them in a particular situation?
Yeah, for attorneys in various states, I would, and I mean there are others, but I would recommend the Special Needs Alliance. SNA is and you can go to their website, Special Needs Alliance. That's a group of lawyers who, in order to be a part of it, have to have lots of experience in doing special needs work. Maybe it's a little self-congratulatory, but it's invitation only, and you just can't join it. You can't just say, I want to pay you the money and be a member of it. You have to be vetted and do a lot of work and do a lot of educational stuff. So that, for lawyers, I would suggest that. Now, it's a pretty exclusive, there aren't a whole lot of people in it. And if someone on the Special Needs Alliance is not in your particular town, I would still call one of those people who are in your state and see if they can make a recommendation, because they're apt to know other people in your specific area who may do this kind of work. So I would do that. In terms of, Special Needs Alliance also has some instructional materials on administering special needs trust and various kinds of benefits. The Social Security Administration their pamphlets on SSI and SSDI and disability benefits for people are actually quite good. Don't answer every question, but they're a good primer. I would certainly think anybody should have those in their library. In terms of administering a special needs trust, it's in the PowerPoint. I co-authored a book it started out being Massachusetts generic, but I think we're on our 5th edition, and it's more universal now. So you can get it from Amazon. It's on administering special needs trust. It's mentioned in the PowerPoint. The other thing I would do in terms of resources is, besides Yachad, is, if your child has Down syndrome, I would, think about, being a member of the Down Syndrome Congress, or, getting advocacy organizations typically will have, articles or resources about these kinds of things. In the ARCS, Associated Retarded Citizens, Alliances of the Mentally Ill, Asperger's Autism Network is a very extensive network. So, it's a lot you have to go over it again, because it is, as I said earlier, kind of difficult to understand all these programs, and some of them, they're all very similar, but they're different too, and they're confusing, not necessarily rational, and maybe some of them are misguided, but that's what we're left to deal with.
All right, I think that's it for questions.
Okay, I really am sorry about the Zoom thing. I can't figure out what happened, but I'm glad we were able to communicate at least over the telephone.
And thank you so much. And everybody who's stuck with us for this hour, over an hour, thank you all for being here. Hello, Julie.
And by the way, my email's on the PowerPoint. If anybody wanted to ask a question or contact me, certainly feel free to do so.
Thank you, Ken. I also put your email in the chat with a few other resources there, and I can send out to everybody if you would like a copy of the PowerPoint or the recording of tonight. if it's okay with you, Ken.
Yeah, absolutely.
Along to people. And everybody, if you would like to join us again in 2 weeks on July 22nd, same time, same Zoom link. Don't worry about the Zoom link, same Zoom link. The topic is who will handle the day-to-day when I can't. And it is led by Sarah Friedman, who is one of our friends in the field from JF and CS. And you're all welcome to join us there too. So it's July 22nd in 2 weeks, Wednesday night, 8:15. Thank you all for joining. Thank you again to Ken, and thank you to Liz for fielding all the questions. Have a wonderful night, everybody.
Thanks so much. Good night, everyone.
Thank you.
Good night. Thank you again, Ken.